I had two charges. First I was convicted of armed robbery I committed, but while I was in the county jail before I went to trial, I was waiting to be arraigned on the armed robbery charge itself. And that's when I had got attacked by a white inmate in the county jail. Stabbed me in my neck, and this was unprovoked. I never had any conversations with the man before, no arguments, no type of interaction at all. And I was sitting at the table, I was writing, and he came up behind me and he stabbed me in my neck. I tried to get away from him. He pursued me around the dormitory, and he tried to stab me again, at which time I defended myself. And he died in the hospital 8 days later. At the time, they didn't charge me at all. They waited and did their investigation. But while I was waiting for the investigation for that to be done, they took me to trial for the armed robbery. And they found me guilty of the armed robbery. But during the sentencing phase of the armed robbery, they used the incident in the county jail they called a murder. They used it prior to me ever being charged, prior to me ever being convicted. They used this to give me a life sentence during the sentencing phase. So I go to prison, and a year later they bring me back for the murder charge. And this was in 1997 when they brought me back. They charged me first. They tried to get me to take a plea for manslaughter, but I refused the plea because it was a clear case. It was a clear-cut case of self-defense. Mm-hmm. So they take me to trial. In the first trial, I have a hung jury because the three black women that were on the jury had refused to see it any other way, especially after the evidence. So they hang that jury and they take me to trial again. They bring me back from prison, pick another jury. This time it's one black woman and like the rest of the jurors are white. And the judge, during the deliberation, the jury came out and asked the judge if I could be found guilty of involuntary manslaughter. The judge said no, I have to be found guilty of murder or nothing. But according to the law, reasonable doubt was established with this question from the jury, which was supposed to have been, my attorney was supposed to move for a direct acquittal of murder because reasonable doubt had been established that I was not guilty of murder. The jury felt like my charge should have been involuntary manslaughter and not murder. And this was supposed to automatically have acquitted me of murder. But they didn't do it. And also, I did not add, let me add this. I had multiple documents from the county jail that from the deceit prior act of violence in the county jail during his incarceration prior to his attack on me. And they had the Clayton County Jail had diagnosed this man as a threat to himself and the others and had placed him on involuntary protective custody and had mandated that he was not to be allowed out of his cell without being in handcuffs and being under a two-man escort. But they had this man out walking around after this diagnosis, and this is how he was able to attack me. So they wouldn't allow this evidence to be admitted into court because they didn't want an indictment against themselves. So to cover up their negligence and the violation of my constitutional rights, they convict me of this murder. They prejudice the jury to convict me of the murder. When it's a clear-cut case of self-defense, according to the official code of Georgia annotated, OCGA 16-3-21, it states that a man is justified in slaying his antagonist to prevent a felony from being committed against him. And aggravated assault is a felony. So, according to the law, this should have been a justifiable homicide and or a self-defense. And I should have been convicted. And then I had the deceased mother in the case. She wrote a letter to the investigator and told them about how her son was racist and that he wanted to die and that he was found somebody who he was going to have to kill him or he was going to make kill him. And he hated blacks, all the different stuff, his children's mother or his daughter's mother, everybody who in his family was writing statements to the investigator about how he was a racist and he was dangerous and he was violent and how he hated black people, and this was his objective all along. He didn't want to live, and he was going to make a black man killer.
David, if I may, and I also want everybody to know this, that was not included in the court documents. WCU was able to get their hands on these documents, so we did submit this to parole and pardons because, now it's showing a different perspective that the courts or the jury wasn't allowed to hear, right? So that's why this is so important, because we did submit all of that to parole with his packet. So I just wanted to briefly state that.
All right, we're going to go because we got a lot of people in here. So I'm going to go to some different people and see if they have any comments. Johnny, I think you raised your hand.
Yeah, why didn't no one file a 1983 lawsuit against the prosecutors in the county jail? Because if you didn't do that, nothing you have was going to have any weight with it. But at least
I did file a 1983 at the time, but I was 19 years old. Well, I had turned 20 years old. I was young at the time. I was gang affiliated. My knowledge of the law at that time was very little, and my ignorance of the law and litigation got my 1983 dismissed without prejudice or with prejudice. I don't remember, because it was, like I said, that was 25 years ago.
Well, that's important to find out.
You got to figure out if it's with or without prejudice.
If it's without prejudice, that means you can refile. That's what that means. And even I think now, in light of new evidence, I still think you can refile after the 2 years, because that means they withheld documents from you that was necessary in order for you to prove your situation. But you should have never been charged with murder, manslaughter, nothing else. It should have been just self-defense. And where's your medical records from when he tried to stab you and he stabbed you in the neck or attempted to stab you?
They have the medical proof. It's even documented on the evidence, the paperwork that I sent to Ms. Quinones. The investigator said, they found the piece of the shank that was broken off of my neck and that my blood was on it. They have the proof.
Okay, so now let's do another thing. There's another vehicle you can use also. Have you ever filed a clemency to the governor? Have you ever done it?
Clemency?
To the governor, yes.
No, sir, I haven't.
You need to take all that paperwork you have, it needs to be condensed down to a clemency and point out the factual information you just shared with us and ask for that particular case, you want to, you're just innocent of it. It doesn't belong to you, And, when the board is appointed by who? The governor or Georgia's legislature? I'm sure it's the governor who appoints the pro board and his members, right? Okay. Stop asking the members to do something that we already clear that they're not going to do. You might as well sit that on the governor's desk and sit that factual information right in there with it. You understand what I'm saying to you?
I do.
Because we have missed these windows of opportunity, because guess what? I don't even believe they would have convicted you of armed robbery had you had the knowledge to utilize, or the attorneys you had, they certainly had the knowledge to do that immediately. And so that this case you wouldn't have never been able to charge you with that. That don't make no sense.
I've never, ever at all denied my guilt of the armed robbery.
I'm not talking about that. That's not what I'm saying to you. I'm saying because of what took place in the county jail and you was under the protection of the law enforcement, and they had a duty that if someone tries to kill you, because that's attempt murder, there ain't no assault. You stab somebody in the neck, that's a murder. That's what it is. If he'd have been successful and hit your jugular vein or something, you'd have been dead. Now, wouldn't be having this conversation.
You're right.
And all the information you had from his mother, from other people, from his wife, from whomever, it clearly established a foundation that this person was suicidal. And guess what? That means they knew it too. And did nothing about it, nothing to stop it, didn't isolate him and put him in either protected custody or solitary confinement. So he would have no access to no one, so he could take his life. Should have been on suicide watch, or whatever. He should have never been in the position in the first place. And his mother and his wife should have sued him also. You all could have enjoined together, literally, because that means that they did nothing to protect his life either.
See, when I was in Clayton County, we was in Lovejoy. This Victor Hill was the arresting officer. The detective that arrested me. You know, I knew Victor Hill from the first time when I first got to Georgia, when I was training at the North Clayton High School with the football team. I used to work out with Victor Hill after my practice, you know, because my mother was a manager at a check on Riverdale Road, and he used to come make the pickups every night. That's how I ended up meeting. And we would go, like, after I would be at football practice, Victor Hill and I would run to the track. We would run together. And that's how I met him. And he was the arresting officer on my case. They didn't have the county jail that they had in Jonesboro. Now, I was in Lovejoy. Back then, like I said, they had the space, they had the opportunity to, because like I said, the dorm that I was in when I was stabbed in the neck by the deceased was supposed to be a segregation unit, but none of the doors locked. You know, the people were sleeping on the floor. It was overcrowded being, you know, so this is how he was able to do what he did. And the people were completely negligent to their own rules and regulations. This, like I said, I was ignorant to the law and to the process of litigation at the time, and that's why they were able to get me to be out of the lawsuit.
And I think that's good, because I think in the beginning of the broadcast, when we was talking earlier with El Sete, this is exactly what he was talking about. This is talking about people not knowing their rights and understanding what they're doing. So we might think that we're following all the stuff, and that might not be the case. It's a lot of stuff that even our panel learns every day. You know, it's a lot of stuff that I learned from them. So, you know, we just gotta know that we gotta do better. We gotta do better in helping these cases, especially for the people that need our help, and how we can be. I use my platform and let them, you know, speak their case. I might not say a lot because I want to give them the opportunity and the time and the floor to present their case, and I want real solutions versus just talking about something that has no solution. So this was the whole reason for the first part of the show, to say no one here, even us, knows everything that we need to know about the law, knows everything that we need to know. And it's good to have conversations like this so everyone can learn. I'm sure that Mr. Scott learned some different things today from our team, as well as Elliot. And you know, we'll continue to have these conversations after the show.